The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcasting Management, or its sponsors. Hi, this is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. We have offices in Sayville and in Garden City and can be reached at 631-569-4334 or on the web at shiverslg.com. Today I wanted to talk a little bit about something that I learned. I actually spent last week in Montreal. We were at the Suffolk County Bar Association's annual Elder Law Committee meeting, and it's usually a very informative meeting. We're required, like a lot of other professions, to take continuing legal education, a certain amount, every 2 years. So in compliance, the attorneys in our office, flew to Montreal, sat through 3 days of education, and came back all the wiser. And one of the things that really stood out to me was what's called a transfer on death deed. A lot of times when I'm meeting with clients, we discuss ways to avoid probate. And probate is the process when someone passes away of taking the will through surrogate's court, validating the will, making sure that it was executed properly in compliance with New York state law, and then the forum where if there's someone who's looking to contest or fight over the will, they have the opportunity to do so during the probate proceeding, as well as any creditors who might feel that they too have a stake to the probate estate. It's their opportunity to do so. So on average, I would say the probate process from start to finish takes at least a year. And that's a really long time if you think about it, because if your child, let's say, inherits your home and they have a home of their own, a family of their own, they're paying their own mortgage, their own taxes, it's very difficult to then say, okay, well, mom or dad passed away and they're now leaving their estate to the children who now are responsible to pay the mortgage, pay the taxes, pay the upkeep of something that they don't have ownership over just yet. Some people really can't afford to do that. So one of the top issues when speaking with my clients is always, what do we do to avoid probate? And really, there's a lot we can do with regard to liquid assets. When you establish a 401k or a life insurance policy, for the most part, you're asked, who would you like to name as beneficiary, successor beneficiary? And when you establish those accounts, the beneficiaries are immediately added to the accounts. When you have a beneficiary designation or you have a joint owner on an account, for example, if you have a checking or savings account that you share ownership with your spouse, you won't have to go through probate someday because the joint owner becomes the automatic owner. Again, as well as if you're a named beneficiary on an asset, that asset's automatically going to pass to the beneficiary named. That's not the case, however, with real estate. And there are so many reasons why we don't recommend clients add their children or their beneficiaries directly to the deed of their home. Now, for a long time, we were transferring the home to children or beneficiaries and retaining what's called a life estate. And what that did is it allowed a client to add a beneficiary to the real estate, but maintain the ability to live in the home for the rest of their life as they always had done. But it was a great way to avoid probate. Now, while we can still do that on an estate planning end, I'm always thinking about the long-term effects as well, because again, we specialize in asset protection. We're elder lawyers. So if you're deeding property to your children, but you're retaining the life estate, what happens if the owner of the home needs to go into a nursing home and the children can't afford to maintain the home? Well, the obvious answer would be they'd sell it. Now, when you transfer ownership of something to your kids and retain a life estate, you're starting that 5-year look back. So you're starting the clock. If 5 years have passed and now you need to go into a nursing home and you show the fact that you've transferred your home over 5 years ago and retained a life estate, you're going to be eligible for full coverage in a nursing home. And the home is not going to be something that is available as an available resource, which is great. However, if your children aren't able to maintain the home and they end up having to sell the home, what most people don't realize is that a life estate has a value. There's a monetary value. And upon the sale of the home, the life tenant is going to receive a portion of the sale proceeds. Now we're taking an asset that was protected, we're liquidating it, it's no longer protected, and the beneficiaries are going to have to give a portion over to the life tenant who's now in a nursing home, and they're going to lose their Medicaid coverage as a result of being over-resourced, having too many assets. Similarly, this transfer on death deed, it sounds great in that you can name a beneficiary so that someday when you pass away, you can avoid probate, and even better than the life estate deed, because with a transfer on death deed, you can change your beneficiary. Whereas with the life estate deed that I was just explaining to you, once you transfer ownership to your kids and retain a life estate, or your beneficiaries and retain a life estate, the only way to rescind the life estate deed is to have their signature. What if they don't want to sign that? Why would they, right? They might turn around and say, sorry, you deeded this property over to me. I'm not giving it back. With the new transfer on death deed that it might even be in effect as of today, to be totally honest with you. With that deed, if you want to change your beneficiaries, you can. However, there's a big however. Medicaid still has the ability, I'm guessing, because liens can be assessed on this property even though you have a transfer on death deed. So what that means is when someone goes into a nursing home and they want to apply for Medicaid, Medicaid considers the home as an exempt resource. However, they do reserve the right to lien the home. So however much they're paying out to the nursing home for the cost of care, if it's $15,000 a month, I assure you every month there's going to be a new lien accumulating in the amount of $15,000 on that home. So someday when the home is sold, it's going to be subject to that lien. If you do a transfer on death deed and you transfer your property to your children, well, my assumption is someday when you pass away, your children will inherit that property. However, if you're in a nursing home accruing a nursing home bill, they're going to inherit it subject to the lien. So really, we haven't done very much to protect the asset. We've avoided probate, which is great. But in the end, there might be nothing left. There might be no equity left in this home, which is why it's very important to speak with an attorney who is familiar with what your long-term goals are. If you're looking to protect assets, if you're looking to make sure your assets pass to your beneficiaries in an efficient, cost-effective manner, make sure that you give us a call. We can help with that. In fact, we are not only taking into consideration who you want as your beneficiaries, how you want to live your life, and what access you want to your assets that you've worked so hard for. We're also taking into consideration, well, the very real possibility that you may need some sort of care, whether it be in your home, whether it be in a nursing home. We want to make sure that all of the planning that's put into place is not only going to guarantee that your assets pass to your beneficiaries, but we also want to guarantee that there's going to be something to pass to your beneficiaries. It's not really, wonderful to learn that you've inherited real estate valued at $600,000, but that with it comes a $600,000 lien that's going to have to be paid off by that beneficiary. And in addition to that, it's very, very important to take into consideration the tax consequences of any planning that you're doing. It's not always a great idea to add your children to your deed, right? It's highly likely that if you purchased your home many years ago, the value has increased dramatically. There are certain tax breaks, capital gains breaks, that you are entitled to that your child, if it's not their primary residence, might not be entitled to. So make sure that you take a holistic approach. We work with wonderful financial advisors and tax advisors, and we can do that for you. Again, this is Valerie Shivers, the host of Will You Trust Me? I can be reached at 631-569-4334 or on the web at shiverslg.com. We'll be right back. Hi, this is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. We are estate planning and elder law attorneys focused on asset protection. We have offices in Sayville and in Garden City and can be reached at 631-569-4334 or on the web at shiverslg.com. Prior to the break, I was talking about some of the education I received while at the Suffolk County Bar Association's annual summer meeting for the elder law section. It's really a great meeting. It moves pretty much across the Eastern Seaboard. And we meet once a year for this summer meeting where we discuss changes in the law. It's a great way to gather our continuing legal education. And one thing that really stuck out to me was this new transfer on death deed. Now, some of you listening in might have property out of state in Florida, and it's a very common New York, Florida connection. Those clients might be familiar with what's called a ladybird deed. And very often clients will ask me, do we have anything like that? Can we add a beneficiary to the deed of our home? However, if we want to make changes or we don't, we're not comfortable with the planning, can we reverse that? And up until now, the answer really has been no when it comes to deeding property. You really can't add a beneficiary or add someone to your deed and remove them without their permission and their signature. And that's always caused a little bit of an issue. In fact, it's always been one of the reasons I've recommended my clients utilize irrevocable trusts to protect their assets, or even revocable trusts to transfer their assets to their beneficiaries with regard to, their real estate, instead of doing this sort of life estate deed, adding children, because that's not reversible. Whereas with an irrevocable trust, it is reversible. So now comes into play this transfer on death deed. And what that means is we now have the ability to, by way of preparing a new deed, add a beneficiary to our real estate and avoid probate. So similarly to how you would add a beneficiary to your life insurance policy or to your investment accounts or even a joint owner to your bank accounts, we now can do the same thing with your real estate, which saves a lot of time and energy if you think about it. The problem is, if you read further into the new law, it shows that we still have the ability, and people still will have the ability to lien the property. Now, that to me is a huge red flag, because even though we're making sure that we avoid probate what happens if someone like Medicaid, which is always something that I'm thinking about when dealing with my clients in particular, it's the elder law attorney in me. What happens if you're in a nursing home, you're receiving care, you're accruing a bill, and Medicaid wants to file a lien against the property? They can still do that with this transfer on death deed. So that being said, what do we do? Quite frankly, we're still left with the same recommendation that I've been speaking about for probably the past 7 years, to be honest, and it's the irrevocable trust. And coupled with the fact that there are definitely going to be some significant law changes when it comes to protecting assets at the end of this year, it's really more important now, more than ever, to establish your trusts and make sure that you've thought about your long-term care. Just the other day, I had clients in my office and they were in their late 50s, and they were explaining to me that they were concerned about making sure that things were just simple for their kids. They've heard about probate. They've heard about the length of time it takes. They were familiar with the fact that even though they had a will, someday their children were going to have to go through the probate process in the event they passed away and pay a lot of money and take a lot of time out of their, day to day just to make sure that the assets passed to the beneficiaries. And they really wanted to avoid all of that. So I explained the fact that, look, I usually recommend irrevocable trusts to my clients when they're in their 60s as a way to not only avoid probate, but also protect your assets from long-term care recovery. And let's be honest, clients nowadays, I have many, many, many clients who are living in their 90s. They're doing well. They're even living independently. And occasionally they're in need of some sort of care. More often than not, they don't want to go into a nursing home. They want to remain in their homes. So I always explain that if we create an irrevocable trust for a client as opposed to a revocable trust is just a trust where you can deed your property, transfer title of ownership of your assets into this trust, and then someday when you pass away, it reads just like a will, and the difference is there is no probate. So upon your passing, everything owned by that revocable trust is going to pass to your beneficiaries simply, without court interference, without creditor interference. There's a huge plus to a revocable trust. But more often than not, when my clients are over the age of 60, I really am recommending the irrevocable trust, because with an irrevocable trust, when you establish and transfer assets to it, you have to wait 5 years before those assets are fully protected from a nursing home Medicaid standpoint. What that means is these assets must be held in an irrevocable trust for 5 years. Once the 5-year look back is over, in the event you need nursing home care, everything in the irrevocable trust is off limits, meaning Medicaid doesn't consider it to be yours. They cannot lien it. They cannot touch it, which is why you want to create these trusts when you're younger and you're healthy. So the clients that I met with, again, they were in their late 50s, and they said, well, would you advise that we create a revocable trust now and then change it to an irrevocable trust in the future? And I said, honestly, I will absolutely recommend a change in the future. For now, the revocable trust would avoid probate, and that's certainly beneficial. But how old are your children? How comfortable are you with your children? And they explained that they really, they trusted their children implicitly, and their children are fairly responsible. If they were to be trustee of the irrevocable trust, they would be able to manage just fine, because quite honestly, when you create an irrevocable trust, there's really not much for the trustees to do during lifetime. In the event you want to sell, they have to sign off on the sale with you. They can't do it without you as the life tenants. But in the event that they do want to sell, it's very quick and simple. And in the event that they don't want to sign off on the sale, you as the creator of the irrevocable trust always have the opportunity to remove and replace your trustee. So in that case, it's kind of a no-brainer. I always tell my clients to think about the irrevocable trust like a corporation. if you're the CEO of a corporation or you're the owner of a corporation, you don't necessarily have to be both. You don't have to own the company and be the CEO. You can appoint a CEO to manage all of the day-to-day, just like if you're appointing a trustee to manage your irrevocable trust. However, if you're not happy with the way the CEO is running things, you can always remove them and replace them with someone else. The flexibility that our trusts provide, and by the way, that's not across the board. I can't speak for every single irrevocable trust. To be honest, I've seen trusts that I've reviewed that have been drafted by other attorneys that have not given that flexibility. I've listened to clients. We know that what they want is to protect their assets. They want to make sure that their beneficiaries are going to inherit their assets. They want to make sure that it's not going to be a difficult process for them to do so. And they want to make sure that it's a quick and painless process and that they maintain control. It's very difficult to tell someone you've worked so hard your whole life to accumulate these assets, to accumulate this wealth. Now, in your golden years, when you're retired and you're traveling and you're enjoying life, put your children in control. That's a really hard pill to swallow. So with the trust that we've established, we've made it so that you still are very much in control. You're holding the reins. You can dictate what happens, when it happens, if the trustee's doing what you want them to do, if they're not, and that is a great benefit. I encourage you to give us a call. We will look at your estate plan from start to finish and make sure that we've checked off all of those boxes and put everything into place in the best way possible. This is Valerie Shivers, the host of Will You Trust Me, airing Saturday mornings at 11:30 a.m. I can be reached at 631-569-4334 or on the web at shiverslg.com. Have a great weekend. The views and opinions expressed on this program are not necessarily those of this station, JVC Broadcasting Management, or its sponsors.